Good afternoon, everybody. I am Allison Mata, and I am your host of Defense Diaries, bringing you our continuing coverage of the state of Indiana versus Richard Allen. So I have Bob's notes from today's session. The the notes are kind of difficult today, so it's going to be broad strokes. But before I get into that, although I have promised to do these, um, you know, more easily streamlined for the podcast, but I'm dying to know, what are we talking about? A juror outburst. I need to know. Sleuthy tells me that she heard that a juror yelled at McClellan to let the fucking expert talk. I don't know. I don't know if uh, where Sleuthy's getting her information from, but I feel like we need to discuss that before I get into the notes. So let's see. Oh, nobody said the F word. Right, but, like, basically saying, let the expert talk." Um, but where did we hear this from? I mean, I'm not on social media, so I guess could be any number of places. That's kind of crazy. Just trying to see if there's anyone else talking about the a juror said so Julie says a juror said loudly, "Let him answer." Um, alright. So, getting back to this afternoon. So, Bob didn't verbally give me any broad strokes, which I was desperately trying to get him to do. So, what I have are his notes. So, let me like I said, I'm gonna give you guys broad strokes, and let's see what we got. So, it's actually started with Betsy Blair, and basically, she just said that she had been to the trails uh, that day twice. She got there at 1:45, left around 2:15. There were no cars at the mayor's lot when she first arrived. She talked about turning left on 300 North and passing the old CPS lot, and she saw a vehicle parked at that lot that had backed in, and that's why she noticed it. It had angles. She was asked if it reminded her of any vehicle that she had seen on this earth, and she said it reminded her of her father's 6S Mercury Comet. When she was asked about the color, she said that she didn't say it was bright colored, not yellow or red. She said, "I know I didn't say it was bright colored, not yellow or red," but that she said that it was not black. The car could not be black. There's some notes here, and Bob will have to tell you guys about it on the evening live, but it sounds like at first when she said it, it came out like it could be black, and Bob put a note that Andy almost swallowed his tongue, LOL, but she corrected herself to not. Then there was a sketch by Betsy Blair of the vehicle that she saw, and I don't know if that's something that we have, and if it is, uh, someone can send it and I'll share it on the screen here. On cross-examination, she said that the vehicle was backed in, it had angles, it was a nondescript color four-door sedan. And then they just talked about if her memory had changed, and her answer was, "I feel confident that that was the vehicle, the car that I saw, the one in the sketch." So we got a jury question that alarms me, and that is it possible that the vehicle parked belonged to an employee? Followed no answers, by the way. Followed with another question. I think it's a separate question because it's written separately as a second question in his notes. Do you know if it belonged to an employee? Now, my understanding is that building was abandoned at the time. That building, the CPS building was abandoned, which is why they called it the old CPS lot. I don't know whether Betsy Blair would have known that or not known that. I don't know if they got into it. So that'll have to be something else that we circle back with Bob and Bob touches um, on the evening session. The the next witness was a Stuart Garrison. He's a went to Harvard Mechanical School. He's board certified. Oh, medical school. Sorry, guys. There is another expert later on. So this is the medical expert, board certified in psychology. He goes through his background, his CV gets in, his curriculum vitae. He has a clinical practice. He works on cases dealing with solitary confinement. Sometimes he does that pro bono. He lectures. And what he was asked to do here was examine whether Richard Allen being held in solitary may have contributed to his incriminating statements. He either reviewed or did an independent medical expert's report. So I don't know if that was his or if he reviewed the other defense expert's report. He listened to the audio recordings, the phone calls, solitary confinement uh, cameras, and the guards and the inmates' information about things that were stated. So he talks a little bit about just solitary confinement in general. He talked about how he became familiar with Richard Allen's confinement, which was through Dr. Walla's reports, and Dr. Walla again was the psychologist in the jail who testified for the state earlier. The other uh, doctors in the facilities reports, the videos, all of those things. He talked about standards, about how long people are supposed to be in solitary confinement, talked about how it can cause delirium and memory disappears and all the things that can happen adversely to someone who is kept like that, including psychosis and having the inability to form rational thoughts, becoming suicidal, tricks of the mind, things like that. Now they talk about we're getting more into specifically Richard Allen, and he was asked if he listened to the phone calls, and he said yes. He said that he absolutely saw symptoms of delirium. He had classic hallucinating behavior, and then he talks about false memories. And that's when you repeatedly relive or start hearing or thinking about something, you start to believe, um, and that it's sort of like he called it a game of telephone. When someone says something over and over, you start to believe it. And like I said, Bob will have to get into that better. But overall, what he says is he believes that these are uh, that those were not truthful, actual confessions. For cross examination, and it looks like it was, well, Bob will have to tell you who it was who handled the cross examination, talks about that he about people, how they recover real memories, and basically just went through kind of how it was, difficult to determine. Sorry. So, there's not much I can make out about this, but it looks like it was basically kinda just challenging him about how he determines what's a real memory and what's not a real memory, and Bob will have to go into more detail with you on that, and then Rosie comes back and says, regardless of the basically, does the fact that someone's in solitary confinement have a massive impact on a person's mental state and psychiatric state? So, here's the jury questions. These I felt were much better from thinking that the jury seems to be grasping or more defense oriented, I guess I would say, or more even handed, even if that's a better way to look at it. But do you believe that psychotic behavior can go back to normal behavior after a person's removed from solitary confinement? And he said generally yes. Do you believe that a completely normal person can become psychotic after months of solitary confinement? Answer: absolutely. Now, I think that's a very important question because it's getting to the point where I was concerned that the jury is going to think, well, the kind of person who is this bonkers and who eats his own feces and does all these things, that's the kind of person who could have killed somebody. So I think that that was a very good question. And like I said, Bob, when he goes through his live tonight and maybe provides some more details and fleshes all of this out, maybe we can find out if the defense did a better job of kind of painting that picture, or if it wasn't for the jury, if that information would never have gotten in, if that would have never been um, very clear. All right, now we have the forensic expert who is a firearm and tool mark examiner, and that's Dr. Aaron Warren. So basically, I'm just going to go right to what his findings were. Here's the thing: this expert did not do his own examination. What he did was evaluate the state's expert's opinion and point out all the things that that expert did wrong, but did not do it right. Did not examine the unspent casing himself, didn't do any of his own testing, simply criticized basically and criticized the state's expert and said, based on what the state's expert has put here, he found that there was insufficient agreement. So he basically indicated that the pictures were very good. He could see that a telescopic image is just as good as him doing it from a microscope on his own. The defense sort of got out there that he didn't ask for anything additional, meaning he didn't ask the defense to get him anything more, i.e., the bullet. However, when pressed during cross and during jury questions, he says he was only hired to evaluate and analyze Oberg's opinion. And he said that the pictures and her reports and her everything that Oberg did was enough for him to form an opinion. And he said he got into how microscopic photos are very important documentation. They're used to refresh the examiner's recollection for lab accreditation. You have to properly document and validate your work. You have to be able to illustrate the work and the process and the observations that led to the conclusions so the work can be shown to rise to the level of fact or something like that. Basically saying, like, "Shows your work. Here's the proof I did what I did. It's legitimate." And at the end of the day, he said that he does something to get the best picture as possible. So then he goes over the class characteristics, the subclass, and the individual, same as, um, the state's expert did earlier. And they asked what relevance of the videos shown to the jury. What's the relevance of the video shown to the jury? And he said there was no relevance. It didn't show her work. So I don't know if the state's expert used a video. Um, he talked about how labs have been shut down because they couldn't like show their work and they weren't able to distinguish between subclasses. That actually happened in Rhode Island. And then he talked about two other people who were shut down. He talked about an unfired round, ejected, removed magazine, and the gun. He talked about when a cartridge case has been fired, it's a high amount of pressure when the weapon's being fired. So he said he was familiar with the unspent casing, Richard Allen's gun, the round that was found in the house, and he ultimately said that it's not appropriate to compare a cycled round with a fired round, because the pressure and time are different between the 2. He indicated that it's done sometimes, but it's comparing apple to oranges. They talk about how Oberg was unable to repeat, and recreate the markings by cycling, and he said that, no, she could not do that, and she used fired rounds to make her comparison, and that she should have had to prove that the marks are repeatable and reproducible through the racking process, through the cycling process. You need an apple to apple comparison, and that was not done here. Bob will have to tell you if they got into anything further, but there was an indication that he testified that there are no error rate studies for comparisons of unspent versus fired. I don't know if the answer is because it's not done. There's not going to be studies comparing apples to oranges. So then Luttrell steps in and says that this looks like a preliminary question about did he physically observe, uh, that he didn't physically inspect the unspent casing found at the scene. And then Luttrell said, "So you can't form an opinion?" And he answered wrong. "No, I can form an opinion." So he talked about basically, going through the photos and that she had found a potential for subclass for ejector, which he actually did agree with, but she didn't show any research for that there was potential for other subclassifications. There was nothing about the barrel hood and the documentation, or barrel hood documentation. There was no research that tool, it's not something that they ever see done. Something to that effect. Bob's gonna have to go through it, but at some point, he said that Luttrell lost his shit. So, the question was, is it possible that what you can see from her work to make a determination of individual characteristics? And he said, "No, not from what he has seen." So he talked about how he reviewed the projector marks, some triangular marks. He did comparisons, the microscopic. images and ultimately found that that uh, there were some marks of that were hallmarks of his subclass. So he would subtract certain marks and look at the finer marks because those are the only marks with the potential for individual um, characterizations or classifications. Talks about all the standard he relies on. He examined um, he examined everything applying these standards to the extractor, the barrel, the ejector, and he said there is insufficient agreement. So he made the exact opposite conclusion that the state did. And then there was just some other questions about recognizing what a slide was and that manufacturers, um, have something about the particular force that's used in different manufacturers, that there was no research about certain things. Again, like I said, um, Bob will have to go through all of this. And then on cross, he basically just went through the fact that he didn't even write a report, he didn't do his own examination, that the tool marks, persist for he agreed that tool marks persist to up to 5 years. There's a subclass or family characteristics, and you can kind of whittle down the field of possible tools, and then he said that some tools can be used by multiple weapons, and that different tools are made by different machines, like the ejector. The ejectors are made by different, um, machines. There's some stuff that comes from assembly of a weapon, yes. There are some third-party vendors. So this is where I guess Luttrell lost his shit. He's asking about Mrs. Oberg had concerns about the ejector subclass, and he asks, "Did she articulate any concerns about subclass characteristics of the extractor or the barrel force?" And the answer was no, and that's where Bob wrote, "Luttrell lost his shit." Now, this says that he indicated that their expert, Oberg, had more experience than him, and then he was asked again, "Are you suggesting that Oberg just forgot to put information about subclass characteristics of the extractor and the barrel force?" And he said, "Yes, she did not put it in." He was like, "Well, you don't do that either, do you?" And the answer was, "If it's a specific case that I'm researching or yeah, that I'm researching." So he asked him, "The bottom line is a tool mark is a tool mark, correct?" And the answer was, "No, that is not correct." He talked about, just some general questions about photographs and reaching a conclusion. He said, "Can you use another examiner's photograph to testify about your conclusions?" And he said, "Yes, that's very frequently done." "Have you testified that you can't reach a conclusion based on photographs alone?" And he said that there was a specific case, like a specific case where he could not do that. And Bob will have to let you know if they circled back and he explained, what why that was in that specific case. He indicated the most important tool in a firearm examination is himself, so the examiner. And he said that comparison microscopically um, was a critical part of making a comparison. And he said, well, you can use a third microscopic, I think he was saying photographs, like someone else's photographs. He's trained the training manual that the AFTE uses. And then Rosie asked, that he didn't ask to see the round or the gun. And he said, no, I was asked to review the documents. Oh, no, I think this was still a trial. Mr. Rosie asked you if you had everything that you needed. Um, he didn't ask you you didn't ask for the round, something up to that extent. And he said he does offer physical examination, um, that he would have used his companion. Sorry, guys, give me a second. I'm starting to think there's something in this basement that makes my allergies act up as soon as I get down here. And maybe actually this was Rosie because it looks like this was redirect. Did you make yourself available for a deposition to the state? Yes. Now we have jury questions. These jury questions indicate that the jury is buying the tool mark analysis and believes that it seems like there's at least some of them who believe that the evidence shows that this is a match. So he's asked um, if changes in like your position and certain tools can change the marks, and how can you distinguish between that? Um, and Bob will have to get into more of the answers. And then he's like, is using, cleaning, reassembly, does that change individual characteristics? No, unless a tool was dropped on something hard. They asked about photographs of ejector marks. Do you know if the manufacturer keeps track of subclass? No, I think is the answer. No, not that he doesn't know, but that they don't. Is there a reason you didn't conduct your own physical test? And he answers, reviewing the documentation was what I was requested to do. Now, people, this drives me insane. Why they did not have their expert do their own evaluation is beyond me. It's something that lawyers do sometimes when look, it's not the defense's job to figure out the truth, right? It's not us to figure out what's what. We're just supposed to poke holes in what the prosecution has done and in the prosecution's evidence. So I understand this mentality of lawyers. They're just look at what their expert did and tell the jury why it's wrong and um that you have a different opinion based on that. Or maybe the guy really did tell them, these are sufficient for me. I can tell right off here. I can tell very clearly off these photographs that that is an insufficient, uh, that there is insufficient agreement in these markings. But it just would have been better to have him evaluate and look at it himself with his own eyes. So the jurors are asking these questions. Is there a reason you didn't conduct your own physical examination? Reviewing the document was what I was requested to do. They asked that he could have done his own physical evaluation. They asked if it would have been, if he had done his own analysis, if he would be able to make more conclusions. And he said that, he couldn't, eh, maybe it's hard to say, could go either way, something to that effect. Are you a certified firearm examiner? Bob didn't write the answer, but he knows it. Would manual cycling be, I think it's just asking like it would reflect differently depending on the force used because I can't make out the writings, but it's definitely depending on the force. About the markings, would they be different, darker or lighter? Okay. Would it make it lighter or darker depending on the force used? For an extractor, probably not force, but the speed by which you're doing it. Okay. Did you look for subclass markings on the cartridge? I cannot tell from the ejector pictures in the report. So maybe he should have done his own damn comparison. Photographs, but then or maybe he's saying he can. Well, it says I cannot tell from the ejector picture. And like I said, Bob will have to give you more details, but it says a photograph can be as effective as comparison with a microscope. Kind of, he keeps drilling that in. What is the relevance of cartridges having subclass characteristics? And I'm assuming that that answer was basically not much because the subclass characteristics don't really, as we know, that just gets you sort of, um, I'm buying a house. I'm gonna take a farmhouse, so now you got farmhouses or you got 2 stories or 1 story, like just kind of narrowing it down. It's definitely not anything that shows that it's the same gun. So Bob Bob will have to go over those answers um, when he's doing his live tonight. Are you aware that Miss Oberg's findings were verified by a second individual, meaning the person in her office? And then Bob will have to go through this because he talks about, they ask if it was a blind, a semi-blind, or a fully blind, or maybe that's the answer that the expert gave. Um, and he talked about there being no latent clues. And he's asked, is the verification process, they're looking at the report? Is that part of it? And then Luttrell asks, verification was done without knowing what the findings by Oberg. And then this says something about clues. It's the same word that was used earlier. No contact clues, no context clues, no latent clues. I don't know. And the fact that there was a verification, they would have maintained that it was an agreement because he would be going off of what her clues were, I guess. Are you aw and then he asks if he is aware that the extractor has a recessed groove that was, um, an individual characteristic. It's either asking it's either it seems like we've decided this is a jury question and not a Luttrell question that they're asking, and I think what they're asking is, are you aware um, that the state's expert said that there was a groove, uh, that was an individual characteristic, and that he said he was, but that Oberg did not properly document it. She didn't really report that, and again, Bob will have to get to you with it because it's not something he was able to flesh out all in writing. One of the other questions was, "Is it normal practice for you not to prepare a report?" Very good question, gets a very good answer, yes, 50% of the time. So that it's not like this, "Ooh, he didn't prepare a report." Um, and then the last thing was something regarding, manufacturer parts, and looks like there was an answer about the ejector was made by its own machine, as was something else, and it's not, um, necessarily the extractor that maybe made the marks, or I can't tell you. I can't tell you which, but that's all we have from Bob's notes for this afternoon. It's gonna be important to catch his live tonight because there's so much more that he needs to sort of flesh out that is not something we could get from his notes. I do wish that the defense had their expert do his own independent analysis, his own evaluation, him look at everything, um, under his own microscope, but at the end of the day, what we got is Betsy Blair saying the car that she saw was a Mercury Comet. Looks nothing like Richard Allen's car, wasn't even the same color as Richard Allen's car. Then we have the jury saying, "Well, couldn't that car have just been some other person's random car?" Which, goes to show, like, they don't know what we know. They're not holding on to the fact that the state went and asked, "We need to know about this car that was parked at the CPS lot," and that's been like, that their story, even though it was asked by the defense to other witnesses. So your theory falls apart if Richard Allen wasn't parked at that CPS lot until, X time or date, because they're focusing on, well, doesn't matter that wasn't his car could have been somewhere else. So it seems that Betsy Blair is not as helpful to the defense as the defense may have thought, at least based on those jury questions. Obviously, not all the jury questions get asked. That's just one juror. We don't know what the other people are thinking. I'm just sort of saying it's possible that Betsy Blair did not have the same impact on the jury as I anticipated it would, as the defense anticipated it would, and maybe it did. Maybe she did. And then the next expert being the uh, false confessions expert. I keep looking in my email. Bob told me there was a motion in limine filed today, but it has not hit, at least not yet. And I keep checking, and I reached out to try and get it from the clerk. So it hasn't hit yet, but the state's trying to get a limiting instruction as to the false confessions expert who testified today. And just to summarize what we just went over, basically said he thought that these were not, these were false memories, that and that it was all result of the solitary confinement, the psychosis, and at least the jury questions there, I think, are more even-handed, and they show there are people still thinking of this from the defense perspective. And then lastly, with the expert, tool mark expert, I think it shows that this defense still has a ways to go to prove to this, uh, to demonstrate for this jury that that evidence is not as strong as they think it is not something that can provide proof beyond a reasonable doubt by any means. But again, it's hard to tell what people are thinking based on the questions. Again, not all the questions are read, but that's all I have for you guys from the notes. But I am going to go through your questions now. And I'm Dizzy's trying to get me some more information on the jury questions, more than what Bob had in his notes. Oh, we're talking about the jury. Amber says that um, Lauren at HTC said it happened, the outburst on on her lunch live. And Dizzy says a juror asked Blair if she thought the car could have belonged to someone working at the CPS building, but Blair said the building looked abandoned, but no one checked to see if anyone worked there. So hopefully the defense will be able to get out through, I think they still have Kathy Allen up, through somebody that that was an abandoned building. I don't know if Kathy Allen would particularly know, and I don't know who else they have that they can get that out there. Um, True Crime True Crochet, thank you very much, very generous, good to see you. Yes, don't forget to like, guys, don't forget to like, guys. Dizzy says the state experts saw some of the videos only. I think that Sean asks, "It's still mind-boggling she fired that test round instead of racking it by hand." No, it's I would absolutely agree. Shiraz, thank you very much for gifting 5 Defense Diaries memberships. Miss Always Right Ryan, thank you for your generosity. How could he check the bullet if the state's inspector fired it to make it match? Okay, so the state's expert didn't fire the unspent bullet, the one that was found at the scene. What she fired were her test bullets. So instead of when you're doing this testing, you're supposed to recreate what happened. So if a gun was fired, you fire the gun and you compare the 2 bullets, a new bullet that you're just doing for the comparison and the original bullet. In this case, she should have cycled several bullets and compared those to the one that she found on the ground at the scene. She tried that. She was unable to recreate those markings by just cycling them. So she resorted to firing them. Now she's not firing, she's firing new bullets, brand new bullets of the same, same type, and she's firing them with Richard Allen's gun, and then she's comparing those bullets to the one that was found at the unspent casing that was found at the crime scene. So hopefully that explains that. But thank you very much. I appreciate the super sticker. Sleuthy says, "Lies. That is not what Oberg testified to." Um, I'm thinking I wish I could go back through Bob's notes because I didn't necessarily recall that. Well, so Jennifer Ray says, "Do you think they'll dismiss the juror who shouted out?" I hope not. I mean, I guess it depends. I don't think so, but somebody that was in the courtroom, I don't know if Lauren had mentioned, like, how did the judge respond when this happened? Um, but no, I don't think that they can do that. I don't know, it's an unusual I've never had a juror say anything, like, ever. So, but I don't think so. And CH points out reports for the expert to do a report, it would have cost money. So, um, that might be a reason there's not a report. I'm trying to keep my chair from swiveling, and I just realized that it's swiveling again, so, whatever. It is what it is. So, Evan Maurer, Allie, would you still think that defense experts still did enough to discredit the testing methods that match in the mind of the jury? I think so, like, in my mind, but some of those questions worry me, and I got I was under the that was a jury question about the individual characteristics, so I don't know if it was the jury or the so Dizzy sent me some more, um give me 1 second, guys. Alright. Malo says the jury question could be saying it's a nothing burger, the car sighting. Well, yeah, they could be saying that, but I think that what the defense wants them to say is not, "Oh, well, the car means nothing." I They wanna say, "Well, they still cited Richard Allen's car, and the car she saw just happened to be somebody's parked somewhere." Uh, that's what I'm not getting from that they've decided that it's not. Yes, basically, they're saying it's a nothing burger, but we don't the defense doesn't want them saying it's a nothing burger. The defense wants them saying, "Oh, great, the defense just proved it wasn't Richard Allen's car all along." So, okay, so let me go over some what the media has been reporting about some of the questions here. So Luttrell had asked, Oberg noted 3 different tool markings making strengthened results, right? And he says no. He's like, "No, that's not what she said." Luttrell asked if Warren agrees on the chamber hood in the report, and Warren says, "Some argument which is not sufficient." Luttrell asked, "The test-fired cartridge in this case was suitable in Oberg's conclusion?" And he said, "Yes, that was her conclusion." Luttrell specifically asked, "Were you trained to use another examiner's photograph to testify about CMS in court?" And he said, "Yeah." And he asked, "In 2021, did you indicate that you did not use CMS?" And he said, "Well, it just might have not been applicable in that case." Alright, let me get to the jury. Alright. How would Okay, right, so nobody's notes had the answer to this one. Warren said that his role was to educate the attorneys on what the documentation was and see if it supported the conclusion. Would doing your own analysis have been more conclusive? And the answer that they wrote here is hard to say. They also have not a lot of answers for some of this. Would individual markings be different depending on who cycles it? And he said the documentation of Oberg does not support a conclusion. Okay. So there's no answer here. Um, and it was a jury question. Are you aware Allen's gun's ejector was recessed and had similar markings to markings made on the cartridge? Bob's note says actually individualized. Jury questions. It says that has a recessed groove that was an individual characteristic. Um, and the media didn't have an answer. What are the chances that the cartridge at the scene matches the test bullets? Higher likelihood of gun just in Indiana. It doesn't seem like they got the answer right, but it seems like he's saying it's just a higher likelihood of it just matching a gun in Indiana. Um, so that didn't help all that much more, but at least I gave you some other stuff there. Uh, Kate asks, "How does Bob feel the jury is feeling?" I don't know, gonna have to ask him. It's hard to say. Why do they feel the girls and Vina Nicholson, why do they feel the girls were already dead when the phone stopped working? I have no idea. It's just their theory, and it's based on nothing. It's based on absolutely nothing. Emmy says, "Why is HTC the only one reporting the juror thing?" Hey, we just reported it. I would think it would be big news if it's true. I'm sure she wouldn't say it if it didn't happen. But maybe she heard something and maybe it was under the guy's breath. Maybe I don't know. I don't know. I have no idea how Gull responded. That's why I asked you guys if you heard anything. Moon Goddess, thank you for becoming a YouTube member. Is it true if there's confession, there can be no lawsuit afterwards? If no, that's absolutely not true. I mean, there's no confession. They're calling it a confession. The the defense and the defendant are saying, I was not saying that I did anything. And I'll tell you, there are no specifics in that confession. Literally. Every word he says is stuff that was completely it literally falls in line with the down the hill, like, I was and I probably already said this before, but you don't have your everyday average person saying, "I was lying in wait." Like, that he didn't say those words, okay? But, not on his own accord, okay? That's words that were fed to him if he said them. Either he didn't say them or they were fed to him. And I followed them onto the bridge, and then I did something with the gun. Don't forget state's theory is you could hear the gun, so I did something with the gun. The bullet falls out, okay? Then I tell the girls to go, down the hill. Then I was gonna, assault them, but I was interrupted, and we've heard, Barb McDonald very clearly said it was widely discussed in the community and amongst law enforcement, their position that the perpetrator was interrupted when Brad Weber came home, which they used to say was at 3:30. Brad Weber came home and that, so that that's why he didn't assault them because, you've got a child completely undressed. It just makes no sense. Um, and then all that you're left with is a van. I mean, he had already told the police. He went to his mom's, he had beers, he went to the house, he got his jacket. I mean, literally there's not one new like actual detail other than the thing that interrupted him was a van, and as I'm sure most of you know, that had been definitely out there. It could have been something if he's being fed information that he was fed, if he was doing his own researching, which a lot of people in Delphi were keeping up on this, they would have seen those facts. So, but my answer to Maced Mama is no. Now, if there had been like an actual confession that was like excluded for some reason pre-trial, they didn't read them the rights. And no, you can't sue when you're found not guilty, not when you admit that you did it. But the issue is here. This is not the court would have to find that was an actual admission that rose to the level uh, that barred recovery, and I don't think in this situation that would ever be the case. But I don't know. Elisa, maybe I'm thick, but in a case where victims weren't shot, what's all the hullabaloo about a bullet? So it was just that an unspent casing was found at the scene, and they claim that it fell out when the perpetrator unalived the girls, and that they compared that to Richard Allen's weapon. And the state is claiming that that there was sufficient agreement between Allen's weapon and an unfired, unspent casing that was found at the crime scene. I don't know any of this stuff about jurors who snapped. Let's see. And I don't have any new super stickers, so I guess that's it. I guess that's all we got for today. Guys, come back um, for Bob's live this evening. Get all the details from him. I'm gonna do one more check of my email to see if I got anything from the clerk. Nope. Still do not have the state's motion in limine. Well, just literally got an email. Let's just see what that is. Not not it. All right, guys. So that's all we have for this afternoon. I don't know what juror snapped. I don't know anything about it. I learned it the same as you guys when I got here. Um, and um and like Sleuthy confirmed this as well. And I think everyone's hearing, you guys are all hearing as much as we all know. So thanks again, guys. See you soon. Bye. Oh, wait. Crime time croquet. We'll bring this up on Bob's next live too, since I already said bye. But thank you for your generosity. She thinks the theory was that the girls were led away at gunpoint, and that proves there was a gun. Yes, that is accurate, that the state claims that the girls were led away at gunpoint, and then there was an unspent bullet found, uh, right by the bodies at the crime scene. So, again, thank you for your generosity. Alright, guys, now I'm really going. Bye.